If you are married to a person who's not a U.S. citizen and you have a sizable estate, you need to pay special attention here. That's because the IRS is a bit weary of your spouse since they think that they'll be unable to collect all the estate taxes that will become due from you and your spouse. You see, normally there's no tax on transfers of property between a husband and wife. The IRS figures no problem. We'll collect transfer taxes when the surviving spouse passes away and leaves those assets to someone else. But where there's a non-U.S. citizen spouse, the IRS wants to tax transfers to that non-U.S. citizen spouse right away because they think the money might wind up being sent back to the old country without estate taxes ever having been collected from it. Please note, however, that this is not really a problem if the U.S. citizen's estate is worth less than his or her estate tax exemption amount at the time of death. Oops, now I've done it. I just started talking about taxes, and usually when I do that, people's eyes start to glaze over. Well, don't worry, because after this video, you can learn more about these rules in the tax planning section. But for now, let me just say that if a person has less than $1 million in his or her total estate, then transfer taxes should not be a problem. If estate taxes are a problem, though, and the surviving spouse is not a U.S. citizen, such taxes may be deferred through the use of a qualified domestic trust, known as a QDOT. So, for example, if an American husband dies with a non-U.S. citizen wife and a large estate, any amount over his lifetime estate tax exemption can be temporarily sheltered and held for the benefit of his non-U.S. citizen wife with a QDOT. The QDOT does this by delaying the obligation to pay estate tax until the death of the non-U.S. citizen spouse. If your spouse is not a U.S. citizen, please set up a free initial consultation here at the trust store to discuss your particular situation further.